my background is primarily in the federal system as an assistant federal public defender. My name is Michelle, by the way. And I think of things in federal terms. And so it seemed on November 9th, about 3 a.m. Eastern time, that a lot of the momentum that had been happening was going to grind to a halt, at least in the federal system. And that has caused me to think and feel many things over time. It's really great to sit here amongst an academic audience with a lot of students here, a lot of my students here. I'm so glad to see you, who are going to be the future practitioners that are going to take these ideas that you've heard from all sides of the aisle and all different perspectives and put them into your practice. So that's fantastic. The question was posed, what can we do to maintain the momentum on reducing mass incarceration as prosecutors and defenders? So that's who you have on this panel. You have people who are former prosecutors, former defenders, current prosecutors, people who have worked on both sides of the aisle, and we're going to ask you some questions, both me and my co-moderator, Steve.
Good afternoon. I'd like to echo Michelle's comments and thank the Justice Programs Office. They put together a great agenda here. And just as a recap, you know, we started the morning here talking about racial and ethnic disproportionality within the criminal justice system. We moved on to talking about police relations and kind of the boots on the ground, the first contact with community. We've talked about front end, pretrial release, programs, and now we're talking about the key criminal justice actors, you know, prosecutors and defense lawyers, and as prosecutors may be seen as the gatekeeper to individuals that are either diverted from the system or enter the system. And then, of course, we'll conclude our day talking about reentry and kind of the back-end programs. You know, as a prosecutor in Detroit, I spent the last 4.5 years of my career investigating non-fatal shootings and homicide cases and vertically prosecuting those cases. So when I stepped in the courtroom, I had a violent offender across the way that we were prosecuting. But oftentimes it seems like there's some finger pointing at the prosecutors when we have this discussion around mass incarceration. We, as the United States, we have a population of 5% of the world, yet we incarcerate 25% of the people worldwide. So I guess we've gotten good at locking people up. And I want to turn it over to the Commonwealth Attorney here in Richmond. You know, Commonwealth Herring, I just wanted to kind of ask you, as a prosecutor, you know, how do you see this issue of mass incarceration and then the prosecutor's role?
Thank you, Steve. I want to, before I yield this microphone to anybody else, I'm going to make a shameless plug for our hopeful next member of the General Assembly, Steve Jansen. We need more minds like his in Richmond to impact forward-thinking policy. The whole notion of mass incarceration, though, for me, can be a bit of a non-starter. So at the risk of your wrath, I think I had to come to terms with this issue 4 or 5 years ago when our prior mayor in Richmond authorized a jail that could house a census 25 to 30% smaller than the existing census. And there was no planning on how to reduce the census. And so they looked to stakeholders, and I was among them, and they said, well, reduce the jail population. And there was no funding to reduce the jail population. There was no blueprint, no protocol, no framework, no nothing. And we put our heads together and came up with some ideas for doing just that, reducing jail population. But in the exercise, we had to do a data dive. And we had to look at the people in the jail and try to gauge the extent to which the people who were there should have been there. I concede there were too many people in jail pre-trial. But the jail was not full of nonviolent offenders. The other thing that we discovered was in a city like Richmond, a mid-tier, moderate-paced city, turns out you gotta mess up right much before you end up in jail, right? In other words, you don't end up in jail on your maiden voyage in a city like Richmond. You end up in jail after your 5th or 6th time before the court. And for most people, that is an indication that we are just about at the right point. So here's the way that I've reconciled this. If you assume that there's valid probable cause for the arrest, and you assume that we haven't wrongfully accused the offender, right, then the communities call on government, they call on law enforcement to do something. And that something has to be a response. And so even if the harmed, affected community is of color and the offender is of color, the folks in the community look to us to do something. And that something has to send a message that reflects the community's risk tolerance, right? And so I am loath to use the term mass incarceration because it's laden with value judgment. I think communities allocate resources, they make decisions to detain offenders as a function of their respective tolerance for risk, right? So I think, or at least what I've decided in Richmond, is to try to reframe this conversation and focus more on what I've concluded to be the default prosecution trajectory, the if-then model. If arrested, then prosecuted and likely jail. That, to me, is a much more fertile conversation. You come to me with mass incarceration, my defense hackles go up immediately. You come to me and you challenge our propensity to reflexively prosecute, I'm gonna listen. And I'm gonna consider ideas for diversion that try to achieve some efficiencies and proficiencies and that are grounded in strategy. In other words, that challenge the default reflexive practice of prosecuting. But mass incarceration, to me, is a non-starter.
Kevin, you got a response?
Sure. Kevin Tully. I'm the public defender in Mecklenburg County, which is in Charlotte, which is in North Carolina.
Go Tar Heels, by the way.
Go Tar Heels. You know, we're here and we're talking about redefining the purpose of incarceration. And I think if we're going to talk about redefining it, we have to start with defining it, right? What was historically the purpose of incarceration? And I do take some issue with this, and I hope we can do that collegially. But the truth is that the purpose, and historically now there are things, Michelle Alexander's book, The New Jim Crow, the documentary 13th, the sad truth, the real truth in this country from the outset, the purpose of incarceration was to subjugate an entire race of people and their communities. That produced a culture which was in existence when all of us began practicing. And so we don't even see it. And sometimes that's why it hackles us when we hear those terms. But it produced a culture that dehumanizes people, that treats the criminal system like it's a business, that puts a premium on expediency and cost. And that culture is what needs to change if we are going to maintain any type of momentum in a reform movement. I'm here to talk a little bit about the role of the PDs, and we are not blameless in this. It would be easy, and sometimes I think prosecutors and police and judges can feel that the defense is pointing the finger, it's all them. We have to own our part in what's happened. But I think what our role currently is if we got here by dehumanizing people who come through the system, who better than public defenders than to bring the human element back in to where it should be? Who better to humanize our clients than public defenders? We also need to be at the table when talk about reform is occurring, and I think it is happening. And lastly, a strong public defender is needed to hold the system accountable, hold the system's feet to the fire if and when reforms are put to paper. Because then they're meaningless, they're only on paper if they're not practiced. And culture and system has its own momentum, and unless there is vigilance and constant challenging, any reform will be meaningless and not lasting. I think the people from New Jersey who were here earlier exemplified this well. They recognized in the role of the public defender there, recognizing that there was a need to change, bringing human stories to decision makers like legislators. They were at the table when the reforms were written, and they are now holding the system's feet to the fire. You heard the prosecutor say that 55% of the detention requests have been granted. That's because public defenders were at the other table arguing and saying, we've changed the way things are being done, and reminding judges of that. So I do think we can redefine what the purposes are, and I'm glad that public defenders are and should be playing a role in it.
So, in order for public defenders to do the job of humanizing their clients, they need the opportunity to get to know their clients. They need the opportunity to do investigation on guilt and innocence, and also investigation on social history, characteristics, and background. And all of that takes resources, and all of that takes a legislative will to give those resources. And oftentimes it's an uphill battle. Why would we give money to lawyers for criminals? I can't tell you how many times I've heard that in state legislatures. It's frustrating. I think we've made a lot of progress in the last 10 years towards that. But generally speaking, outside of the federal system and in the majority of states, public defenders don't have time to look into guilt or innocence properly and effectively, let alone humanize their clients, because they don't have the resources to have a reasonable caseload to do so. That is a problem. Fortunately, there are amazing models out there, like the Public Defender Services model here in DC, the Platinum Gold, wonderful standard. And so if you could say something, please, about the role of having the resources to tell human stories that judges and criminal justice actors, decision makers, pretrial services, those who are going to decide on diversion, can hear to make fact-based choices.
Sure, thank you. Hi, everyone, and I'm sorry for those of you who have my back. Hello. Oh, hi, LaShawna. So I'm Jamie Argento Rodriguez, the chief of the Community Defender Division here at PDS in DC. So I actually thank you for the question, because I think it's an important one. And I also want to sort of say, with an asterisk up front, that PDS is resource rich. And so because we're funded by Congress as a model public defender agency, there are hundreds, thousands of public defender organizations and agencies throughout the country who don't sit where I sit, with the opportunity to say that they're in a community defender division, or that they have social workers, full-time investigators, have a pool of resources for experts to test our clients. So those things are not things that I take for granted, given that I am the non-traditional public defender, having come up through the juvenile justice world, done special education advocacy in our civil division, and then now working in the community defender division. So I'm saying that up front for you to know that I recognize that public defenders don't always have the resources that PDS has. But as I was listening this morning and thinking about other things to say, and listening to the other panelists and listening to Kevin, who, by the way, I went to UNC for law school, so that's why I yelled, "Go Tar Heels." Yeah, exactly. So I was thinking about the question of resources, actually, and how resources only work when we are confident and courageous enough to take on the issues of race and classism that affect our clients. Because public defenders, we don't have the private defense bar here, but many folks may have experience working in the private world. But the folks that are representing indigent defense clients have to address those issues of race and poverty. because we don't get to the point of implementing resources in a meaningful way if we're not willing to take those issues head on. And I don't mean just saying, yes, there are poor black and brown people in the criminal justice system. We have to say we don't accept it, and we're not going to accept it any longer, and we're going to do something about it. So that's the first thing. So resources are important, but they're only important if folks are willing to realize, like with the opioid epidemic, that it impacts our children, it impacts our communities, and that we won't accept this for our communities, and that we want to do something about it. So I don't know if it's exactly the answer that folks were looking for, but that's my position on this and why resources can be implemented. A couple of other things that I think may be viewed as radical, and we've seen this happen in some of our southern state partners, that public defenders should refuse to take the unethical large caseloads that they're faced with. We can't have public defenders walking in jurisdictions. I have friends who have practiced in Cook County with 900 cases on their caseload. That's bigger than my kid's high school. I mean, I don't know how I would even be able to look at 900 people's case files and know where to start. And I think we need to support our public defenders and defense counsel privately, folks that are appointed by courts throughout the country, not just here in DC, but in the small places, maybe Scranton or wherever we're talking about, where people don't have access to resources and their public defenders are overworked. If you walked into an emergency room and you knew that your emergency room doctor had 900 patients waiting for him, you would leave. And that's not fair to our clients who are faced with their liberty being taken or at risk of losing their liberty because their defense attorney doesn't have the ability to represent them in a meaningful way. And then finally, I'll say on this point regarding resources, I think that public defenders must partner with our civil legal services counterparts for civil Gideon. We must partner with the folks that are helping our clients who are addressing the direct impact of their criminal convictions in all the other areas of their lives. So this is where I'm going to soapbox, because I am not the traditional public defender that received a client and then went just to trial. I come at this from the angle of, what are the other issues that my clients are facing? And they're not collateral, folks. They're real and they're immediate. When someone is arrested because they're driving in that car that Cynthia Jones was talking about that was stolen, maybe it was stolen from someone's grandmother or something. She loses her car. He loses access to getting to school. Somebody's rent may be impacted. These things are real and they're immediate, and we can't avoid them. And our civil legal services partners, particularly in this environment right now, where LSC funding is being stripped or at risk of being stripped, it's tremendous. So I encourage us all as public defenders, prosecutors, judges, legislators, to look to all of the attorneys who are involved in helping people who are impacted by poverty and the lack of access to justice to do something about it.
So, Michael, I think Jamie brought up a great issue regarding resources, and her office, being here in a federal enclave, has resources that we don't see at the state and local level. So as we talk about prosecutorial discretion and having an impact on the incarceration rate, what do you do if your office maybe lacks those resources? And what are the conversations you're having in Virginia with your colleagues and maybe even nationally regarding the needs of prosecutors and how we wield our discretion?
So I have to ask for, how about conversational immunity from my head of DCJS, who happens to be here? Not only are our localities starved for resources, but if you happen to be in a state that is philosophically, or at least legislatively, opposed to anything other than the traditional prosecution trajectory, you've got to run, well, you could, right? You got to run black ops. You literally have to do things, not do them to scale because you don't want to draw too much attention to yourself. And then you wait for somebody to tell you to stop doing it, which means you never quite have the resources to do things beyond 2 or 3 precincts in a city. We don't reach the level and enjoy the successes that my colleagues in Charlotte, Mecklenburg do. At the local level, for example, I'm trying to persuade our stakeholders to do root cause analysis. I heard Anna refer to it in the previous panel. And I was trying to pitch it to our new energetic young mayor, who I think is right-sided, appropriately, I mean right-sided on these issues. And I couldn't figure out why his assistant was giving us sort of soft pushback. And then it clicked. The problem with root cause analysis for a mayor is it's like peeling off the bandage. Once you expose the abscess, if you don't have something to treat the abscess, then all you've got is the damned abscess. So when you reveal concentrated poverty, if you reveal lack of any degree of market velocity in a community, government is incapable at a local level of the seven-figure funding, because it's really a seven-figure budget that we're talking about, to bend the curve on this sort of stuff. In places like Richmond, until the private sector is comfortable collaborating with government, we will never enjoy the successes that you all do here in a place like DC, because our city will never have the resources to fund it from a purely governmental standpoint. And so I'm looking forward to hearing some of the things that have happened in Charlotte, and maybe hearing from some of you in some of your other localities, in hopes that there are models out there where the cities and the counties have figured out a way to tap into monies other than the traditional government coffers.
Just real briefly to say that we are fortunate in Charlotte that we have a local government, a local county government that is willing to sit and listen and look at research and what works and to fund it. Even though we're a state system, they supplement the funding. But one of the things we've done in our local jurisdiction is stop fighting each other for funding. And I know that sounds strange, but that's the position they put us all in, right? Because nobody has enough resources. And so when you're fighting over scarce resources, you turn on each other. And one of the things that has happened in Mecklenburg and Charlotte is we've come together and advocate as a whole for more funding across the board. And I've always said this about prosecutors: it doesn't do my clients any good to be up against a prosecutor who's got a pile of case files, people's files in front of them. We need a prosecutor who is able to have the time to read it, understand it, so that when we come to meet with them, things make sense and we can reach some kind of an accord if it's possible. The only time it's useful for my client is when we're sitting down at a trial, for the prosecutor to be that unprepared. So what we've done is to, recognizing we're only trying 3% or 5% cases, to say, no, everybody needs more resources and stop pitting us against each other. So one thing that can happen if reformers believe that public defenders play a critical role, we need the prosecutors, we need the judges, we need everybody involved to advocate for funding for public defenders as well as their own.
So we talk about criminal justice reinvestment in an earlier panel, or justice reinvestment, and my radical thought about resources is maybe we have far too many already in the criminal justice system, and that there was some discussion earlier from Ana Yanez about looking at other countries and what they do in terms of avoiding falling too far through a social safety net, by actually investing in a social safety net, by not fighting about taking away health care from people. So they have mental health services and they're not being caught up in the criminal justice system in the same way as people that we have here who are so desperate and so poor and without job training, and all of a sudden the criminal justice system is looked upon to answer all these questions. Maybe we could at least notice what other first world democracies are doing. And okay, that's my comment. My question is for Santha. You spent a long time on the public defense side, and now you are working in the new entity of the Attorney General's Office for the District of Columbia, and you bring a lot of defense experience to bear on the issues of juvenile justice, but you're now in a situation of looking at it through a new lens, and I'm wondering if through that new lens you have some wisdom to share with us about what the Attorney General, what the prosecutors can be doing to help us reduce mass incarceration?
I'm not sure I would elevate it to wisdom, but because I've only been a prosecutor for 12 months after 32 years on the other side, so, but I would say that I think a priority for this Attorney General, Carl Racine, here in the district is, and he's our first elected Attorney General, is to sort of keep kids from getting, okay, sorry. Excuse me. I can cough loudly. Keep kids from sort of penetrating the system, if you will. And so we try to come up as much as possible, consistent with public safety, because we are the public safety division, with off-ramps, because I guess the research has shown that, you know, as all of us perhaps grew up thinking we would be, you know, having an image of what we would be like, or the sort of niche we would find for ourselves in our lives. Kids who penetrate the system early, that becomes their self-image. And so we actually do more harm than good, as long as it's consistent with the public safety, if we let them get too entrenched into the system. So we have great success with a diversion program called ACE Diversion, which is alternative to the court experience, which is run by the DC Department of Human Services. We have a juvenile behavioral diversion court, which is a therapeutic mental health court. I have tried to imbue the line assistants with a sort of trauma-informed lens through which to view illegal behaviors by kids, and to sort of look at what the genesis of behavior is, and address the root causes as a way to keep them from coming back through the system. So those are some of the ways we've tried to sort of figure out off-ramps for kids who get arrested.
Is there an openness to maybe some of your innovative ideas that come from your 32 years of experience in your office? Or do you have to struggle against a mentality to not be thinking about trauma, but maybe more about protection of the community? Not the trauma of the accused, but the protection of the community.
I think that when I came on board, I mean, I have to say I was the third public defender, albeit maybe the one who had been a public defender for the longest, who had Carl Racine had brought on board. And I do think that to some extent I was sort of the last straw, if you will, for some of the people in the office. That said, I think that there are others of them who welcome a change from a very sort of formulaic approach to, you know, if this is the charge, this is the plea, and, you know, we have to do things this way, and that sort of rigidity. So while there's definitely some resistance and some eye rolling and, you know, there she goes again sort of stuff, I don't think it's across the board. I think some people actually sort of welcome it. And we've tried to also do it through training. I mean, that this is evidence-based. This is what works. This isn't about being so-called soft on crime, which I think is sort of the cross I came into the office bearing. And it may take a long time for me to shed in the eyes of some people.
So President Obama penned a 55-page article regarding criminal justice reform, and we've touched upon it a little bit earlier, but he didn't mention public defenders in this role. Maybe Kevin or Jamie or anybody on the panel, how do we maybe engage public defenders to kind of take up some of this leadership? And what is this whole notion of now a holistic defense that we're looking at recently, in the last maybe 5-10 years?
So I'm happy to maybe start with the latter question and then move backwards. So holistic or client-centered representation is a hallmark of our practice in many offices now throughout the country. Because what we've realized is that when we look at the client not just as their charge, but as what they need, we get better results for the client and for their communities. So at PDS, and I love this sort of continuum metaphor or analogy, at PDS, we have a continuum of representation for our clients, starting with, obviously, the traditional, you're arrested and you are appointed a public defender, but we have folks along the trajectory of the case who are going to represent you specifically regarding the issues you may be facing. So for instance, in my division, we have several of my colleagues from the Prisoner and Reentry Legal Services Program, which is one of the programs in my division. They focus specifically on prisoners' rights issues, including conditions of confinement and rights while folks are incarcerated, both in the DC jail, so pre-trial, all the way through when folks are sent away and sentenced. And in DC, anyone who serves a felony sentence or over a year, they're sent out to the Federal Bureau of Prisons. So our folks are working all along that continuum of incarceration. And they're working to preserve their rights and enforce their rights while they're incarcerated, but also to try to help them extricate themselves from the status of incarceration. And that's not easy to do, right? Public defenders traditionally don't have that resource to be expending on folks who are already pulled into the deep end of the system. But there are other avenues that we do this too. We have a civil legal services division at PDS. We have a parole division that specifically addresses the issues of folks who have been released on parole or supervised release and are facing issues regarding revocation. We have obviously an appellate division, and we have a special litigation division that looks at maybe impact work that we should be doing. And these are all things that public defenders are the best to do. It's our clients, it's their issues, whether it be a Fourth Amendment issue at trial or it's some kind of issue related to the Eighth Amendment post-incarceration. They're our clients, and they're the folks that we saw when they walked in, and it's folks that we see when they're exiting the system. And again, using the sort of medical model, which I like to liken public defense how it maybe could be, the good medical model, not the one that you're like rolled through, but integrative health is this huge push right now. I myself participate in integrative health program, and you have everybody serving you where you need. So you're the focus, and then your providers come around you, and that's how it should be for the legal services model. So public defenders are best situated to do that because we see the clients at their most vulnerable points. We know what their legal issues are, and we can identify them, and we may not be the experts on every individual legal issue, but we then can network, and we should be reaching out to the folks that have the expertise.
Thanks, and just to the second point, or maybe the first one, I can't remember, about President Obama's 55-page report on the need for reform. Here's the leader of our free world who has all the resources available to him, all the research available to him, puts together this thing, truly believes in reform, and not one time in those 55 pages mentions public defenders. And this is what I'm talking about in saying we need to change a culture. We have a culture that doesn't recognize the role of the public defender currently or in the future in maintaining and establishing reform. Jonathan Rapping, good friend of mine, who started the Gideon's Promise program, which trains, supports, and encourages young public defenders primarily throughout the Southeast, recently wrote a piece in the New York Times commenting on this. And I'll steal directly from Jonathan. When he points this out, when he talks about the, I forget the name of the show, the popular one on crime on TV, Law and Order. And he says right at the beginning of that show, they say there are two important organizations. And what are they? The police, who make arrests, and no, the prosecutors who put those people away. There's no mention of the public defenders. We don't even exist. So this is a culture that does need to change, and I think one of the ways we do that, to answer your question, is to show up at symposiums like this, put that out there. Hopefully some people listen and pay attention and make a note of it, and the next time they go to a discussion, raise that issue. And I invite the judges, prosecutors, others who believe in the reforms, who believe in the role that we might play as defenders in maintaining those reforms, to do the same.
And I will comment, this is also an issue on the United States Sentencing Commission, where there is representatives from the United States Attorney's Office, or one who is an ex officio member, and the federal defenders have been fighting for 15 plus years to have the same ex officio status on the United States Sentencing Commission, to have their concerns heard as experts in federal criminal justice, and to date, deaf ears. So, but they're still fighting and trying to get their place in that, but that is a problem. We talked a lot today about no entry. We talked about diversion and reentry, and we have an expert on working with successful reentry here. But I wanted to ask you, Kevin, on the idea of these no-entry programs. The LEAD program in Seattle was discussed, for instance, where my understanding of that program is police can use their training and discretion, their training in mental health, their training in opiate addiction, right on the street to decide this is not a case for the criminal justice system, but we have another facility where we can bring these folks. We can do harm reduction and avoid the criminal justice system. In Richmond, if you had law enforcement making those choices, what kind of buy-in would there have to be from your office to allow that? What kind of training would be necessary to make it work, and how would the public feel about it?
This is such a timely but substantive question. One, I'm really impressed by the notion of holistic defense. I think you all are successful at it because you've allocated resources to positions so that they can be dedicated to things other than the charge. Most prosecutors' offices don't have the equivalent of a sentencing specialist or a person or a unit that looks at alternatives to traditional prosecution. And so I think that's probably one step for prosecutors to take. LEAD has been successful, I think, in Seattle. LEAD has expanded to Albany. It has become, it is a term that has acquired its own currency value like reentry did 7 or 8 years ago, right? So it is recognized as an evidence-based practice. I think LEAD is as successful, again, as a community is willing to tolerate it, because you are, in effect, telling the community that a person who has harmed the community in some way will not be held accountable in the way that people have come to expect or formulate accountability. Instead, that person will be accommodated, treated, dealt with in the community. You can have all the goodwill in the world. That is, you can have a well-intended prosecutor that collaborates wonderfully with the defense bar, be it public or private. But if you don't have the resources to fund the program, all you're doing is diverting people to a black hole of goodwill, which I think in the long run harms the very communities that they were taken from in the first place. So stated differently, if I send people back to the housing project that they were arrested in, and I haven't done anything to address the trigger that caused the behavior, then where are they going to offend? They're not going to do it on River Road, one of the more affluent parts of my city. They're going to reoffend in the same housing project. And that's going to cause the same affected community of people to have less faith and credibility in what we do. Now, here's where it gets a little more complicated, and I won't monopolize this microphone, right? But every dollar that we divert away or reallocate from the sheriff's office or from the police department to something on the front end has to assume a 3 to 5 year term on the yield, right? It's going to take 3 to 5 years for you to see the yield on your reinvestment. But the minute you reallocate the funds, you affect an FTE. You affect a position. Every $100,000 you take away from the sheriff is 2 fewer deputies. And so it has a tangible, visible impact on a personnel line item. And you have to persuade people that it's worth the short-term sacrifice for an invisible, longer-term yield. And that is a tough conversation to have. We get it as egghead academics inside baseball, but you try having that conversation in a community meeting, oh boy, it's tough. You know, it's like campaigning. As my friend knows, you get 20 seconds to make your pitch. And on the 21st second, the door begins to close, right? So you jam your card through the door and hope they vote for you on election day. And it's tough. So, you know, I'm actually looking forward to hearing from other folks how they sell programs like LEAD in their communities, because I'm familiar with the studies on LEAD, but there's very little research on the sale of the program.
Okay, well, maybe Michelle, I don't know if we've asked enough questions. Maybe we should save 10 minutes for some questions from the audience. If they have any, maybe they could be brought down.
May I make a comment just about the whole trajectory and the role the public defender can play in ending mass incarceration, sort of circling us back to this, just before we take a question?
Sure.
In DC, when I first started 15 years ago at the Public Defender Service, and most recently in my current division in 2008, there was a facility called Oak Hill Youth Center. And at the time it held, I can't remember the number, someone can correct, it's probably about 240 kids. And it was often maxed out, 240. And it was decrepit and rat infested, and there were bugs and there was abuse. It was not Rikers, but it was our Rikers, right, for kids. And at the time, Vinny Schiraldi, who's now in New York, or he was in New York, now he's at Harvard, where he went on to Harvard, as many folks do, I guess. But he came as a reformer, right? And he came in to reform our juvenile justice system, and as the executive director of the Department of Youth Rehabilitation Services said, I'm going to build a committed facility for 60 kids. So I'm going to reduce it to a fourth of what it currently is. And folks did exactly that. They said, oh my God, there's no way you're going to reduce this to a quarter of what we have and it's going to work. And I'm telling you today that those 60 beds are not full. We have reduced it so it's less than a quarter full. And we spent money. We built a state-of-the-art facility, has a award-winning, Harvard award-winning school, and it is a great place if you have to be incarcerated, but it's less than a quarter of what it was when I came to PDS, and it was my first, I felt like I was walking into Shawshank Redemption when I walked onto the grounds of Oak Hill. But it can be done, and it can be done with a really mindful and artful way of using it for the kids who are most in need, and I think we can do this on the adult side, right? So many of my adult clients are 18 and 1 day old, right? So they're kids still, and yes, they matriculate and they end up in jail, like Glenn's friends who may be there for 30 years, but these are people that don't have to be incarcerated, and we can do it because there's evidence that there are facilities where it's been done. So I just put that out there as like, look at what's been done in DC. I'm not saying it's perfect, because I fight those folks too, and part of my juvenile services program is inside the facilities advocating, but the public defenders were part of it. We sued them because of the conditions of confinement, and we advocated for those clients, and we helped make that reform possible.
First question. I just want to circle back to the first speaker and talk about the impact of incarceration on individuals. And in my own practice, I have represented so many, mostly men, who served very long sentences and came out and had no ability or no skills to deal with the outside world. They didn't have anywhere to live, they didn't have anywhere to work. They were so institutionalized that within a month or 6 weeks of being released from the halfway house, they're back on a supervised release violation. And the federal system, which is supposed to have all these great programs, is still a very local system. Some places do, some places don't. Where I practiced in the District of Maryland in Baltimore at the time, there was nowhere to put them, except back in prison to serve out the rest of their time. And so this idea of the impact of people who are just warehoused in cages without any meaningful programming, when they come out, the likelihood of them going right back in and contributing to the problem and taking up another bed or another cage because they can't function is still something that the federal system as a whole needs to deal with. And I'm curious how that problem manifests itself in the states, in North Carolina and in Virginia.
Well, the first thing I would say is what you just described serves the original purpose of incarceration really well, right? It was never intended to be rehabilitative. It was meant to subjugate and to devastate whole communities, and it did that really well. But what we are challenged with as public defenders is what is our role upon reentry. We have certain rules and laws and mandates as to what we can and cannot do in terms of the practice of law. In North Carolina, once our client's case is resolved, we no longer represent that client. And we're limited as to what we can do for that client. With the advent of an introduction of holistic practices in our office and full-time social workers, if we're lucky, we can make a connection with a client while they are our client. So when they do come home, they do come by the office and ask for some help, and we may be able to get it for them. But what we can do as public defenders, at least, is advocate for local government to fund programs specifically designed for people coming back, and telling that human story of reentry and what prison does, not just to that individual, but what it does to their family and their whole community.
I have to be honest. I'm glad that I don't set the city's budget. I am sympathetic to the idea of reentry, and I lean way left, just so we're clear. Perhaps not as far left as Ellie, but I lean way left. I have a hard time, though, reallocating budgets to increase the emphasis on reentry when we know that we do very little to address the triggers for the behavior. I think it makes more sense, at the risk of offending anybody in the room, to be smarter about who we felonize first and then detain than it does to spend more money on people who are being released, perhaps at the expense of non-offending people, particularly young people in under-resourced communities who end up in our courthouses. So I don't know, as an old economics professor said to me, you know, if you've got to choose between fish and butter, which do you choose? I don't know. I'm also troubled by this notion of the original purpose of the justice system. I haven't read The New Jim Crow. I started another publication, Slavery by Another Name. It's a Pulitzer-winning book, and I couldn't get through it. I got about 50% through it, and what I realized was I had trouble going to work. It was too illuminating, right? So I sort of exist in my state of somewhat blissful ignorance, and I go to work and I try to not overbear on my colleagues, many of whom are younger, but I focus on things that I think we can actually achieve, which is avoid felonies. And then when we can't avoid felonies, then we look for opportunities for alternatives to detention to preserve whatever job or income may be in the household. But it's hard for young prosecutors because you're sort of asking them to be schizophrenic. You know, I want you on the one hand to be holistic in your perspective on Steve, be somewhat of a social worker, but then I need you to bare your fangs for Michelle, and I need you to do it in the same docket, and I need you to do it as a human, and I need you to not violate Brady, right? It's tough, and they look at me like I'm the guy in the corner office who's espousing all of these lofty policies but doesn't have to exist on the ground, and so they comply to a degree, I think, in fairness.
So we have 3 questions, and the first one to address to Santha. Based on your time in the criminal justice system, looking at it from both ends, from your personal perspective, if you would, what role can and should prosecutors, and more specifically the Attorney General's office here in DC, have in ending mass incarceration?
Well, just to be clear, and probably everybody knows this, but at the risk of stating the obvious, in the District of Columbia, or the colony of the District of Columbia, the Office of the Attorney General prosecutes all juvenile offenses and a very, very small subset of minor adult offenses. So the vast majority of people who are locked up, for example, at the DC jail and who ultimately may end up in the Federal Bureau of Prisons are being prosecuted by the Office of the United States Attorney in DC. So I can't speak for Channing Phillips. But that said, I mean, I think the role of the, I mean, I do think that a prosecutor has more power, and I guess sort of arguably as a gatekeeper, if you will, than a defense attorney. I mean, let's face it, I spent more than 30 years responding to what was done to me and trying to change the landscape. But as a prosecutor, you're defining that landscape. And that's an awesome responsibility and power. And as a result, if you make reasoned judgments and exercise your discretion mindfully, it seems to me you can have a tremendous impact on incarceration. Of course, ultimately, you know, we don't wear the black robe, so even if we were to take a position, you know, let's say in a given case for someone not to be incarcerated, you know, a judge could decide otherwise. But I do think that prosecutors have an incredible amount of power.
So Kevin, a question for you. Can you talk a bit about North Carolina's open discovery law and how that impact has had on the incarceration rate? And what other tools do you possibly have in your toolbox to address mass incarceration?
Okay, well, take those in order. For those not familiar about, I guess maybe coming up on 20 years, North Carolina passed an open discovery law. It was in direct result to some extremely egregious and very public wrongful convictions in our state that were so public that it shamed the legislature into writing this law, which basically says that the prosecutor, in terms of discovery, must share everything with us, right? That's the gist of it. It is reciprocal in certain aspects, in certain defenses, in certain, if we're using experts and they write a report, we have to share things like that. But what is the effect on mass incarceration? I don't know. It's 20 years, and we're still sending particularly African-American people by busloads to the prison system in North Carolina. So I don't know that it's had a tremendously huge impact on that. But it does, on a case-by-case basis, do have some impact. What it did was it took away from the prosecutor that responsibility, I would call it, You mentioned Brady, right? Before, what the prosecutor had to turn over was really constitutionally mandated if the prosecutor, through their eyes, believed it was exculpatory, right? And what we all know from defense standpoint is they're viewing it in terms of prosecution. You know, I don't know how many times when exculpatory material came up later and I was accusing or confronting the prosecutor and say, why didn't I have this? And they would say, well, it wasn't part of my case, even though it might be exculpatory in general, it wasn't pertinent to my prosecution. And they're not aware of how we're viewing the case or what our defense might be, so they're not even in a position many times to tell what's exculpatory. So what the open discovery law did was kind of relieve them of that responsibility and say, no, you have to give it everything. What happened almost immediately was in a culture where, and it's worse in other places in my state than it is in where I practice, but in a culture where there were prosecutors who were hiding the ball, what the open discovery statute did was move that to the police. Because once the police learned from the prosecutors, hey, everything you give me, I got to give him, guess what? The prosecutors and all of a sudden weren't getting everything themselves. So there was another law that was passed that says that the police are required to turn over to the prosecutor their entire investigative file.
You know, in Richmond, that it takes a defendant 5 times to commit a crime before receiving jail time, yet you're open to innovative prosecutorial strategies. You know, when and where does that occur? And can any of the defendants be reached earlier before they get to that 5th conviction? Compound question here, so hold on. If so, can prosecutors or police actually do it? Or are we looking at other criminal justice interventions to take place, maybe bringing other institutions on board? And maybe to answer that last part of the question, you know, I've always felt once you've reached the courtroom, other institutions have already failed you, and now as a prosecutor, we're trying to handle this matter.
I think it's certainly true in the ideal that once you reach the courtroom, other institutions have failed you. In reality, I'm not so sure that's true. But I think the reason that I'm open to alternative approaches for offenses 1 through 5 is that I have come to understand the consequences for even misdemeanor convictions. Everybody in this room gets the consequences of felony conviction, monetary and with regard to civil rights. I didn't know until fairly recently that because of my work through some folks at John Jay with the Misdemeanor Justice Project, that there are several consequences to misdemeanor convictions. And so I think as a third-term Commonwealth's attorney, who I believe has some responsibility to expend the city's resources smartly, we have to make offenders less expensive, right? And not to dehumanize, but to be real, I can persuade City Hall to do many things if the analysis makes sense financially, even if they disagree in principle. The fewer convictions, certainly the fewer felonies Richmond residents have, the less expensive they are to Richmond taxpayers. And so I'm open to misdemeanor diversion, which is harder, in my opinion, than felony diversion. And I'll tell you why if I have the 30 seconds, because I think it's going to be cheaper for my city. I think misdemeanor diversion is harder because the low-hanging fruit in diversion is something like narcotics use. What's the factor? The narcotics use, and so you treat it. The triggers for misdemeanor criminal behavior are far more nuanced and elusive. And so we're struggling to find and identify models that have been successful at identifying the triggers for misdemeanor behavior. I'm convinced they're out there, and they're probably cheaper than the felony models, but it's easy to get people to nod in agreement because the level of offense and the corresponding level of harm is low, but it's hard to identify a way to actually do misdemeanor diversion.
So, in the last few years, I saw something that I never thought I would see in Congress, which was people on both sides of the aisle coming together and saying, mass incarceration is a problem. Some came at it from a fiscal point of view, and others from a moral and fiscal point of view. Things have changed. We have a new administration. We have a new Attorney General who, when he was a member of Congress, was not in favor of smart on crime legislation, not in favor of smarter sentencing law, who has expressed views about the criminalization of marijuana use and sales and medicalization. And so there's a big question mark, I think, where we're going to go federally from the smart on crime policy, which is now in the dead zone of the Department of Justice website, as is 21st Century Policing. And so there was a great article in the New York Times on Sunday, many of you saw it, that said the future right now is probably in the hands of the states in terms of maintaining this momentum. And so I urge you all, where the federal government is taking very likely at best a pause or a major step back, those of you who are doing the work in the localities and the states, we're going to have to look to you to maintain the momentum to end mass incarceration, be it from police, public defender, prosecutorial, or legislative side. So keep fighting.